We're waiting for a few more folks to join us. I'm just going to wait a second or two. Good afternoon, everyone. Welcome to the second annual Indian Law and History Lecture, which is co-hosted by Maine Conservation Voters and the University of Maine School of Law. I'm Lee Softly, President and Dean of Maine Law, and I'm delighted to see that the Indian Law and History Lecture has now become what we hope will be a permanent part of Maine Law's fall programming. It's an honor for me to introduce today's lecture and to thank the extraordinary steering committee that has helped put together this excellent program, a program that provides a great reminder that the issues addressed today are not limited to the past. They are vital issues that deserve our attention now and in the future. So please join me in thanking the steering committee members, Nolan Altivader, Amber Atala, Ambassador Molly and Dana, Michael Corey Hinton, my good friend Donna Loring, Professor Anthony Moffa, who may still be in Egypt, Chief Rena Newell, Lakota Sanborn, and Will Sedlak. I am grateful to everyone that we were able to nimbly pivot from an in-person program to this online presentation that will allow everyone involved to participate and allow people to join us from across the country. And making that happen were some wonderful folks at Maine Law, to whom I am so grateful. Carrie Wilshusen, Rob Parecka, and Carrie Weiler have brought us successfully together today. We're fortunate that we will hear from Professor Rebecca Sosi of the University of Arizona Law School and Professor Darren Ranco of my alma mater, the University of Maine. The program today will be moderated by Michael Corey Hinton of Drummond Woodsum's Tribal Nations Practice Group. Corey is a citizen of the Passamaquoddy tribe, Sipiak, and his law practice at Drummond Woodsum. He advises tribal nations, and his expertise in federal law, policy, and administrative practice is well known and respected. He also works with nonprofit entities that serve Indigenous, socially disadvantaged, and underprivileged communities. He previously served as president of the Native American Bar Association of Washington, D.C., and we are honored to have him moderating the program today. Corey, the floor is yours.
Thank you so much, Dean Softly. I really appreciate the kind introduction. Ndolu is Corey Hinton, Nujayao, Portland, Wabanakiig, Anuda Beg Zabayeg Naga Balans, Best Gudamagad Nil. My name's Corey Hinton. I live in Portland here in the Dawnland. I'm from Zabayeg, the place at the edge of the water, which is a Passamaquoddy village, and I'm from the Francis family, and I'm a citizen of the Passamaquoddy tribe. I'm pleased to be here today as a moderator for today's Indian Law and History lecture, and we'll kick things off now by turning things over to our first speaker, Professor Darren Ranco. Professor Ranco has a joint appointment in the Department of Anthropology, the Senator George Mitchell Center for Sustainability Solutions, and in the Native American programs, where he serves as chair of Native American programs and coordinator at Native American Research for the University of Maine. His research focuses on the ways in which Indigenous communities in the United States resist environmental destruction by using Indigenous diplomacies and critiques of liberalism to protect natural resources, and how to state knowledge systems rooted in colonial contexts continue to expose Indigenous peoples to an inordinate amount of environmental risk. Professor Ranco teaches classes on Indigenous intellectual property rights, research ethics, environmental justice, and tribal governance. A member of the Penobscot Nation, he is particularly interested in how better research relationships can be made between universities, Native and non-Native researchers, and Indigenous communities. Professor Ranco, the floor is yours. Thank you.
Chiwaliwan, Corey, and everyone. It's a real honor to join you all at noontime, Eastern time. I know there are people joining in different time zones. Just really humbled to be part of this small panel and this event. It means a lot to further the education around our issues. And today we get to talk about the doctrine of discovery. So won't waste any time. I'm going to share my screen and look at that. All right. So the goals of my talk today, of course, some of you probably have heard me speak before. I could speak for hours around any number of things, and this one including. But I really want to connect the doctrine of Christian domination and discovery to the, in particular, to the state of Maine's constitution and action since statehood in 1820. I also talk about the colonial history of what is now Maine as well. I want to show how the hierarchical ethnocentric order of the doctrine of discovery led to intense racialization during the 19th century in particular, and despite its potential use to combat non-federal interests against Indians, has provided for further opportunities of takings of our lands and waters from tribal control well into the 21st century. And I'm thinking, of course, some recent court cases. So what is the doctrine of discovery? It is the international law that regulated nearly 600 years of European colonization of what they refer to as the New World. A lot of indigenous people refer to as Turtle Island, and can be traced to church law in world history to at least the Crusades to quote unquote reclaim the Holy Land starting in 1096. The modern, and I love this idea that the modern day version was imagined and emerged in the 1430s due to Spanish and Portuguese claims to control and colonize, especially the Canary Islands, of course. Again, as they move into the Western Hemisphere, it becomes a much more elaborate set of claims. The scholar, I think many of us consider the Robert J. Miller, the indigenous legal scholar, as a real authority on the doctrine. And of course, like, why are we talking about a 15th century European doctrine? Is because it is not just an interesting relic, in his words, of world history, but remains an applicable principle in many countries and continues to limit the human, sovereign, commercial, and property rights of indigenous peoples and their governments. The doctrine was used by European nations to justify their desires to acquire riches and empires around the world. And by emphasis, the European powers primarily justified these acquisitions and their ambitions by ethnocentric allegations of cultural, racial, governmental, and religious superiority over the rest of the world. And I'll give you the sort of prime example of this. Also, apologies, all of my slides are text slides. I could have just read this, but I wanted to share. Some people like to see the words as well, but I realize that this is an underperformance of PowerPoint as a technology. The text that many of us sort of point to as its first come into being and defining the doctrine of discovery and domination is this papal bull from the Pope in 1455. Which granted Portugal a certain set of powers over the Saracens or Muslims. And this is referred to as the Romanus Pontifex papal bull. And so in that papal bull, the Pope grants Portugal, the king of Portugal, to invade, search out, capture, vanquish, and subdue all Saracens, Muslims, and pagans whatsoever, and all movable and immovable goods whatsoever held and possessed by them, and to reduce their persons to perpetual slavery, and to convert them to his use and profit, to possess these islands, lands, harbors, and seas, and they do of right belong and pertain to the said King Alfonso and his successors. Not surprisingly, in 1493, Spain also sought papal approval for the quote unquote discoveries Columbus made in the quote unquote New World. According to this developing international law and set of principles, Pope Alexander VI issued 3 papal bulls in order that the lands Columbus had quote unquote discovered, which were not hitherto discovered by others, belonged to Spain. The Pope further granted Spain lands in that it would discover in the future if they were not, quote, in the actual possession of any Christian king. This future orientation of not only things you discover, but into the future is a critical part of this superiority of through church doctrine at this time. The Pope then drew a line of demarcation from north to the South Poles, 300 miles west of the Azores, granting Spain title to the lands discovered again and to be discovered west of that line, and granting Portugal the same rights east of the line. In 1494, Spain and Portugal signed the Treaty of Tordesillas, moving the line further west to give Portugal part of the land base of the New World. Isn't that so nice of the Pope to do that? Which explains, of course, why they speak Portuguese in Brazil today. In 1529, in the Treaty of Zaragoza, the countries extended the line around the globe and divided up the Pacific Ocean and its islands and lands. Jealous to acquire empires and riches themselves, England, Holland, France also used this international law to claim rights in North America and elsewhere. It should be noted that the colonial settler societies that resulted from European colonization of much of the world, including the United States, continue to apply the doctrine of discovery against indigenous nations today. And I'm not going to go into all of the elements of that work, but I'm going to try to tell stories that are connected to particularly my tribe, the Penobscot Nation, but also more broadly to the Wabanaki people that still reside here in what is now known as Maine and across our greater Wabanaki territory, which includes areas of what is now considered the country of Canada. I want to focus, there are lots of treaties where this doctrine gets implicated and mobilized and sort of made real in the context of the realities of Indigenous and non-Indigenous people. I'm going to focus on Dummer's Treaty, which is the treaty from 1725. There's another treaty that is more oriented towards the Micmac, Maliseet, and Passamaquoddy in 1726, but is part of the same general set of conditions. The one in 1725 referred to Dummer's Treaty. And this is really sets up some of the false promise of the doctrine discovery and sort of this idea of a singular European and Euro-American notion of a sovereign that has a kind of supremacy. So this treaty, and you can read it in any number of ways, is officially called the Submission and Agreement of the Delegates of the Eastern Indians, addressed a crucial problem of land ownership in Wabanaki English disputed territories, especially in what would be considered the western part of Wabanaki territory, stipulating that the English shall and may peaceably and quietly enter upon, improve, and forever enjoy all and singular their rights of land and former settlements, and be in no ways molested, interrupted, or disturbed therein, saving unto the Wabanaki and their natural descendants, respectively, all their lands, liberties, and properties not dispossessed, not disposed of, possessed, or improved by any of the British subjects as aforesaid. There is a disputed or mistranslated clause, and this is even the title of the treaty, the submission of the Eastern Indians. And this, again, it's hard to explain, but there's the Wabanaki interpretation of this treaty was not about submission. And this is clarified in a letter written by the Penobscot diplomat Lawrence Sogarab, referred to as often as Loron, where he talks about and he expresses to the French, the English, and he sends this letter wherever he could, and he says to everyone, "Do not hence infer that I acknowledge your king as my king and king of my lands. Here lies my distinction, my Indian distinction. God hath willed that I have no king, and I be master of my lands in common. As for what relates to your king, when you have asked me if I acknowledged him for king, I answered yes, but at the same time have made you take notice that I do not understand or acknowledge him for my king, but only that I owed that he was king in his kingdom as the king of France is king in his. So this idea of submission or a false claim of submission, and you're going to hear the notion of the falsity of the doctrine and sort of its fiction a lot, I think, today. But it has very real consequences at the same time. So based on some of these mistranslations, the idea of a religious supremacy as designed in the original sort of papal bulls, as well as misunderstandings, Dummer's Treaty actually led to relative peace for about 20 years or so, which at the time, after a series of French, quote unquote, from the English perspective, French and Indian wars, and for the reality of many indigenous people at the time, was a relative time of peace. And so much so that in 1736, the General Court in Boston even cited, in respect to the idea of a sovereign supremacy and the validity of the treaty itself, sided with the Penobscots against a settler named Samuel Waldo and his Muscungus Company proprietors. Now, these proprietors, like a lot of proprietors, had a patent, and they were trying to take a claim from a patent that had to have some of this sovereign authority attached to it. And they attached that to this vast, vague Plymouth Grant in 1629, which is basically, you know, the whole area of what might be now New England. No one's been able to really understand it. And then also a 1694 sale, which most people consider to be coerced and unclear in its own right, by Madacawando, which the Penobscots had always repudiated and was the basis of Laurent's angry protests of many of the treaty mistranslations during Dummer's Treaty. Now, this is significant because what you have in this case is the sovereign authority at the General Court in Boston siding with the Penobscots against more local constituents, right? More local proprietors who don't have this sort of clear sovereign authority and settling that claim. And that's going to come up quite a bit and hold out both a kind of false promise as Indigenous people as we engage in this sort of sovereign authority discussion, but also invests and reinvests the idea of a kind of supremacy over Indigenous people by these settler, by first the colonial and then the settler governments. And it's all based in supremacy. The doctrine of discovery comes into the United States common law in the famous case Johnson versus McIntosh in 1823. In that there, the US Supreme Court decided that McIntosh, who received a land grant from the United States government, and not Johnson, who was also suspiciously a former Supreme Court justice who received a deed directly from the Piankashaw tribe in 1773 and 1775, and that McIntosh, not Johnson, was the owner of these lands because Indian nations were not considered to be the full owners of their lands after Europeans and then Euro-Americans arrived and claimed a property interest in Indian lands. So this idea that Johnson had a deed without a sovereign backing it up meant that even though it was earlier in time, it was directly with the Indians didn't actually have the right to transfer fully the deed or the property. And that the court held under the doctrine of discovery, Indian nations could only sell their lands to the Euro-American, first European and then Euro-American government that claimed the discovery power over them. And therefore, that the purported sales to Johnson were invalid. Also, it's pretty clear this was a sham or a made-up case. In looking at the record, that this was a controversy that was seeking that was sought out to reach this conclusion. And actually, Johnson and McIntosh, their claims to land did not overlap at all. But we can talk more about that. I wish I could go into that. It's a really interesting idea. The US Supreme Court repeatedly stated in the Johnson versus McIntosh case that the doctrine and the loss of rights suffered by Indian nations were based on the justifications of Christianity and civilization. The court stated, for example, quote, the character and religion of its inhabitants afforded an apology for considering them as a people over whom the superior genius of Europe might claim ascendancy. Ample compensation was made by bestowing on them, the Indian nations, civilization and Christianity in exchange for unlimited independence. So this is the rubric and framework of supremacy, and that puts one group at the higher position of the other. Later on, in the Worcester v. Georgia case, and this is very important in terms of we're trying to understand what can and has happened in the context of the state of Maine, the US Supreme Court maintained the federal preemptive privilege by excluding state authority over tribes. So there was not a similar sovereign claim by a non-federal actor in the Worcester v. Georgia case that there was. And then, of course, go fast forward to this past year, maybe that's being undermined to a certain extent in a recent Supreme Court case that Professor Sosi may or may not talk about. In Maine, this religious and racial hierarchy elements, but without, again, the federal sovereign supremacy, were incorporated into Maine common law in the Maine Supreme Court case, Murch versus Tomer from 1842. Here, this was a contracts case, the court there said that the imbecility on the Indians' part and the dictates of humanity on ours have necessarily prescribed to them their subjection to our paternal control, in disregard of some, at least, the abstract principles of the rights of man. This is probably also a sham case. The idea that there would be a contract case that would go all the way to the Maine Supreme Court perhaps is part of it. There was also some sense that the judges had at the time had some interest in creating this notion that there is sort of a lesser than legal standard for Indians, even though the decision said that the Indian who signed the contract was held liable to that contract, held to that contract, even though they're technically an imbecile. So they wouldn't. So this is actually kind of an in-between place that created the context of an Indian right in the Murch versus Tomer case. The other place where I want us to pay attention to in terms of how the doctrine gets implicated in the context of the state of Maine is in the original state constitution from 1820. Article 2, Section 1, talking about electors. Of course, in 1820, the electors were every male citizen of the United States of the age of 21 years and upwards, excepting paupers, persons under guardianship, and Indians not taxed, having his residence established in the state for the term of 3 months next preceding any election, blah, blah, blah. So this notion that Indians not taxed, again, it's not Indians, this idea of Indians not taxed, not being able to vote becomes a very important part of holding sway in terms of the second class and superiority around Indigenous people's rights. Today, this part of this Constitution states, of course, explicitly, every Indian residing on tribal reservations and otherwise qualified shall be an elector in all county, state, and national elections. Maine is only one of 5 states to have this Indians not taxed in any part of its state constitution. Indians not taxed also appeared in the 14th Amendment as well as some other federal statutes. So it's a commonplace notion. What does this mean? What is Indians not taxed? So it's not exactly alone a racial designation because it presumes that Indians who are taxed could vote. But it also is an interesting form of recognizing tribal sovereignty. I've made this argument before. It reflected, and this is from the Department of Interior, the opinion of Solicitor Margold in 1940. It reflected first the prevalent notion that taxation and representation should go hand in hand. It also reflected government taxation is the principal criterion of government authority over citizens, and that the condition of the Indian living was in his separate and independent, or her separate independent community. So the presumption is that another sovereign authority had this right to tax Indians in its own domain. And finally, being outside the control of either state or federal government, this person was an Indian not taxed, and since did not bear the financial burden of government, not entitled to representation. So that's the logic. It was a different kind of logic, a political logic, that really defined this term. Despite these forms of sovereign recognition, Indians not taxed became racialized and used as justification for second-class citizenship, and coupled with the sovereign supremacy in the plenary power of Congress and the Supreme Court, and the state of Maine claiming this as well, was the defining interpretation by the federal government and state of Maine as to how to treat Indians well into the 20th century. I'm running out of time, of course. I could draw this all the way through. A notable case in what I would call 19th and 20th century contradictions in the context of the state of Maine and this doctrine. The most significant one is the State versus Newell case in 1892, denying the exercise of off-reservation Passamaquoddy Treaty hunting rights. And while both the state and the Passamaquoddies and their lawyers used the name and recognized tribal identity, the court made the argument that because the Passamaquoddies could no longer make war and peace, they could therefore not exercise these treaty rights and were not really a tribe, even though they repeatedly refer to them as the Passamaquoddy tribe in the case. But they're not a tribe anymore because they just made this whole cloth on the spot, make war and peace. I don't even know if that's true. Perhaps the Passamaquoddies could have made war. I'm not saying they would have won, but that idea is just again, looking for a supremacy and a right to ignore from treaties. This case and others like it ignored all of the federal Indian law cases and concepts and maintained Indians as second-class citizens with no rights to manage our own resources or vote, interpreting Indians not taxed purely in racial terms. It was this approach, though, for the state of Maine, ignoring federal law and imposing a racial secondary status that led to the Passamaquoddy versus Morton case and the need for the Maine Indian Claims Settlement Act in 1980. So what are my connecting and not concluding thoughts? In thinking about this doctrine and its legacy all the way through the constructs in Maine common law, federal Indian common law, and how this hinders the exercise of our sovereignty as tribal nations, in 2022, I see the federal government much like those distant sovereign authorities of the 17th and 18th centuries. They're primarily fighting to preserve their own federal control over its interests. And these interests are also endorsed by the doctrine of discovery, right? That's still invested in a singular supreme authority over Indian nations simply because of there being a European or Euro-American sovereign. This control sometimes overlaps with indigenous people, as we are the holders of original agreements that colonizers and settlers benefit from, such as deeds and treaties, and these are the foundations for federal Indian law and the supreme authority. And then, so sometimes our interests overlap, much like they did in the 1730s, or against those proprietors that were trying to claim our lands. But also today, I see the state of Maine much like, and especially in terms of the policy of the governor and the attorney general, much like the local proprietors from that same period, they're fighting both the federal authority over their lands, makes sense, as well as Wabanaki control guaranteed in these early agreements and laws that held sway in previous times. In the 1970s, to make clear that they did not want a nation within a nation, leaders across all political spectrums, Republican, Democrat, Independent, ran on platforms decrying any possible settlement related to the illegal taking of Wabanaki lands by the states of Massachusetts and Maine after the 1790 Federal Non-Intercourse Act, which was an endorsement of this sovereign supremacy authority that treaties are only the purview of the federal government. In some ways, those politicals won. The Maine Indian Claims Settlement Act of 1980 was signed into law without a single dollar from the state of Maine, even though it had taken time and again from tribal funds and that they were managing, quote unquote, for 150 years, and with a diminishment of tribal sovereignty based on clauses in the act treating tribes, for example, as municipalities. So, as I actually conclude, I really think what we deal with is this legacy of mistranslations and poison pills that reinforce and recognize a certain set of authorities that are ethnocentric based on racial and religious superiority. These racist and ethnocentric systems of interpretation still shape the eventual resolution of these mistranslations. Again, we have these Supreme Court cases, justices saying things about, I just thought all the Indians were at war, before Europeans arrived, things that are just rooted in this notion of superiority. And I'm hoping that we can learn from recent engagements and these misunderstandings and find a better way forward than the orientation and the legacies of these interpretations, especially as it relates to these superiorities. So I'll stop there. I could go on, but I really appreciate the time. I did try to connect it and set up Professor Tsosie, who is a much better legal mind than my own.
Professor Ranko, thank you so much. That was a wonderful presentation. I really appreciated how you provided some critical foundational history and then tied it back to the experiences of our people here in the Dawnland. Thank you so much. So folks are aware there is a Q&A feature at the bottom of your panel on the Zoom program, and I'd encourage those out in the audience to please submit questions. We will have a Q&A portion after Professor Tsosie's presentation, which we'll get to in just a minute. And if you are able to submit those questions, we'll do our best to have the presenters answer them in a little while. Before we shift gears and bring Professor Tsosie on, I would just like to acknowledge some of our sponsors. In addition to organizational sponsorships from Maine Law and Maine Conservation Voters, this lecture is supported by a number of other amazing organizations. I'd like to thank those organizations now, which include the American Constitution Society, Bernstein Scher, the Conservation Law Foundation, Drummond Woodsum, the Leadership Education Fund, and Planned Parenthood of Northern New England. Thank you to all of these organizations, to Maine Law and Maine Conservation Voters, for your significant support, which was all necessary to make this event possible. Again, if folks have questions, you can please feel free to drop those in the chat and we'll get to them in a little while. Turning to Professor Tsosie, who I just want to say was my mentor when I was in law school. She's an amazing scholar, an amazing human being, and I'm just so grateful that she's with us here today. Professor Tsosie is a Regents Professor at the James E. Rogers College of Law at the University of Arizona. Professor Tsosie, who is of Yaqui descent, is a faculty member for the Indigenous Peoples Law and Policy Program at the University of Arizona. And she's widely known for her work in the fields of federal Indian law and Indigenous peoples' human rights. Prior to joining the University of Arizona faculty, Professor Tsosie was a Regents Professor and Vice Provost for Inclusion and Community Engagement at Arizona State University. Professor Tsosie was the first faculty executive director for Arizona State University's Indian Legal Program, of which I am a proud alum. And Professor Tsosie served in that position for 15 years. Professor Tsosie has published widely on sovereignty, self-determination, cultural pluralism, environmental policy, and cultural rights. She teaches in the areas of federal Indian law, property, constitutional law, critical race theory, and cultural resources law. Professor Tsosie is a member of the Arizona Bar Association and the California Bar Association. Professor Tsosie serves as a Supreme Court Justice for the Fort McDowell Yavapai Nation and as an associate judge on the San Carlos Tribal Court of Appeals. She received her BA and JD degrees from the University of California, Los Angeles. Professor Tsosie, Thank you again for being here. The floor is yours.
Thank you so much for that wonderful introduction, Corey. It is so good to see you again. And on behalf of everybody at ASU and everybody in Arizona, we just think the world of you and your leadership. And it means so much to me to be here today at your invitation. I also want to thank the Maine Law School, everybody, Dean Softly and the staff have been amazing. Thank you for accommodating my health needs. I really wanted to be there in person, but my health just wouldn't permit it this week. So thank you very much for that accommodation. And Professor Ranko, you gave an amazing, the best overview of the doctrine of discovery that I have seen, and the rich history behind that, which is so ancient by our modern standards, but is still of continuing relevance for federal Indian law, certainly. So thank you. It's an honor to join you on this program. Thank you to Will Sedlick and everybody who worked together to make this happen. And a special thank you to Ms. Donna Loring that I was hoping to meet in person. I had the honor to meet her by video, and she sent me so many resources to help me think about the situation in Maine, the very rich and different cultural histories and political histories and legal histories. So Darren, I'm honored to be with you on this panel, and for Q&A, I think we can have a very rich and robust discussion. In the time that I have, I would like to focus on the legacy of the doctrine of discovery in federal Indian law, which of course is my field. But I also want to talk about the current sort of context for that, which is really one of reclaiming the political, legal, and cultural identities of Indigenous nations in a global space, because the doctrine of discovery, of course, had a global impact. And so the corrective, or the principles of the corrective, are embodied in international human rights law, and particularly the United Nations Declaration on the Rights of Indigenous Peoples, adopted by the UN General Assembly in 2007. And it is rapidly becoming the sort of measuring rod for domestic nation states as they engage Indigenous peoples in the search or query about what self-determination ought to mean in the current day. So I'm going to start with the federal Indian law background. I'm going to move into the human rights framework, and then I'm going to conclude the presentation by looking at how some Indigenous nations are working across the borders that politics and law create for us, but working across those borders to actually achieve self-determination within their ancestral and current territories. So that's a broad undertaking. I'm just going to sketch out the outlines of this and really welcome the Q&A with the audience. So as I get started, I want to say, and this is what I tell my students every year in federal Indian law, I say, look at the land where you are, look at the land where you came from, forget about state borders, forget about international borders, US, Canada, US, Mexico. You are on Indigenous territories. Those territories have a name, they have an identity, and they have Indigenous peoples that belong to those lands. I'm talking to you from Phoenix, Arizona, and so I'm sort of in a place that is claimed by O'odham people, also by Yavapai people and Apache people a little further north. So I am on their territorial homelands, speaking to you today. And why is that important? Because that is the first identity of the people embedded in place. And that is the nature of Indigenous peoples. They are part of their ancestral territories and places. And we don't forget that they have been removed and relocated in some cases. So those ancestral attachments and the current attachments are all a composite of what it means to be an Indigenous people. And the people, it's a different political identity than a federally recognized tribal government, which of course is an important sovereign within our US structure. But the people are the ones who have the attachment to the land and that right of self-determination. And that is what we explore in the modern day. But in the stories about the Dawnland, about the ways in which the Passamaquoddy, Penobscot, and other nations that I was reading about, the Maliseet and others, the Wabanaki people had this intricate confederacy, and that is really the identity that is primordial, that is embedded in the land. The other thing I tell my students is that I can talk to you all day long about federal Indian law. I can test you with hard hypotheticals. I can do all that stuff. I want you to know that federal Indian law, like all types of law, is in many cases based on a legal fiction. It takes something and then it creates a rule about it. And the doctrine of discovery certainly did that for us. So the law falls short of justice. And so when we talk about treaties, and Darren did a great job of building out that treaty discourse over time, that is very important because it really says that the two governments are aligned as sovereigns around certain goals and objectives. Now, what happens if the United States forgets its treaty promises? And it did do a lot of that. So we have situations in, for example, California, where the California tribal nations negotiated treaties in the 19th century with the United States. They were sent to Congress, but the gold rush went into full scope, and those treaties were never ratified by the Senate, and so they ended up in some vault. Does the United States have a treaty promise if that never became a legitimate instrument of law? And here, again, the discourse turns into one of justice, saying that is a solemn agreement, nation to nation, and a nation ought not to turn its back on that goal and promise that was articulated so long ago. So I tell my students, we're going to revise the principles under sort of considerations of justice. My sense, and we can get into this more, is that there was a certain level of federal negligence in the state of Maine where the United States had that obligation and didn't abide by it. And this happened in many, many places across the nation, so that the state government starts to, in a sense, take the place of the federal government under that hierarchy, that political hierarchy that Professor Renko talked about. Now, what happens to agreements negotiated by state governments that do not have the validity of law? And that, of course, is the basis for the Maine Settlement Act. And yet, it is a government-to-government obligation. So in the contemporary world of human rights law, we would say that also is a solemn obligation, that it is an agreement that embodies duties and obligations to the indigenous nations that were part of that land when the federal government engaged in that neglect. So that is the type of analysis that I think is probably productive in the modern day of getting at the heart of what indigenous nations need today to effectuate the right of self-determination. Okay, so step one, the legacy of federal Indian law. And here, Professor Renko's amazing presentation has helped me so much, so I can just keep to the core of it. Federal Indian law is unique because it is a composite of international law, and that was called the Law of Nations in the time that Professor Renko was talking about, and United States constitutional law. And it is a hybrid of those two types of law. It still is a hybrid of those two types of law in international human rights law. So we have to construct the government-to-government relationship in accordance with those principles. The legacy of the doctrine of discovery in federal Indian law has been formative. And so the Johnson v. McIntosh case that Professor Renko talked about, it really was going to the validity of land purchases in the years right before the American Revolution, when these land speculator companies were buying up land from Indian nations, and they were going to assert that they had the title when the United States got formed. So it was a very important case for the United States Supreme Court. And of course, indigenous nations were not represented as parties. The only issue was whether the prior pre-Revolutionary War purchases that resulted in Johnson's claim of title directly from the indigenous nations, whether those would be paramount to the later, I think it was like an 1812 conveyance from the United States government after the United States concluded a war with the Piankashaw Nation and had a treaty of 1794 with that nation, which ceded their land to the United States. And of course, the court said, and Marshall had a choice. There was a choice of law here. He could have gone with the doctrine of conquest under the law of nations, which says if one civilized nation conquers another civilized nation, you respect the civil rights of the inhabitants in that conquered territory, and that includes their rights to property, because they are going to become part of one nation, and you want an assimilation and amalgamation of the people that seems just given the transition in political sovereignties. That is the law of conquest. He said, you know what? We're not going to apply that law because Indian tribes, per the doctrine of discovery, are savage, they're uncivilized, they're non-Christian, and therefore we're going to treat their lands as essentially vacant lands. And that was the doctrine of discovery, where if you're the first to discover a desert island, you claim title to that island if you're a discovering sovereign, because there's nobody to compete with the title. Now, how can an inhabited place be subject to the doctrine of discovery? And there they said it was legally vacant, that uncivilized people did not have a rule of law that the civilized Christian European nations had to respect. And that's why the law of conquest was inapplicable to Native nations land transfers. So did that mean that they didn't have anything to transfer? And Marshall said, no, they did have a form, a very rudimentary form of property right, the right of occupancy and possession. And that right of occupancy and possession became Aboriginal title. Aboriginal title can only be transferred to the European sovereign or its successor in interest, so Great Britain or the United States. Nobody else. You couldn't transfer it to a third party and have it recognized as title. So the title went to the discovering sovereign who settled the lands, and the Native nations had the right of occupancy. And I tell my students, we still have that in our law, and that is the basis for Aboriginal title claims. Does that mean that the United States can just take these? Well, Marshall said you could take it by purchase, treaty, or by conquest, military, involuntary. And of course, our law has grown so that the 1946 Indian Claims Commission Act by statute allowed tribal nations to get statutory compensation for takings of their Aboriginal title. But it is not a constitutionally protected interest, unlike trust reservations today, which are held in federal title, but for the full beneficial interests of Indigenous nations. That is recognized title, and that is compensable if the United States takes it. So that is how it came into federal Indian law. Professor Renko also talked about the Cherokee cases, Marshall's decisions, and these were the Marshall Trilogy, Johnson v. McIntosh, 1823, and then the two Cherokee cases, Cherokee Nation versus Georgia, Worcester versus Georgia. That was when Georgia basically wanted to get rid of the Cherokee Nation, which was fully self-governing and quite civilized, according to every indicator, on its territory, had its own laws, courts, written language, the whole 9 yards. Would Georgia be able to negate the sovereignty of the Cherokee Nation? And they tried directly to close down the Cherokee Nation's institutions of governance and law. They also tried indirectly to regulate non-Indians who were in the Cherokee territory. At the end of the day, what Marshall said is that the Cherokee Nation is a nation fully self-governing on its territory under its law, but under federal protection. It's not a foreign nation because it's incorporated into the United States territory, does not have the right to engage in multilateral agreements with other foreign nations because of the doctrine of discovery. The ultimate title to their lands is in the United States due to the doctrine of discovery. And yet they are under federal protection on their lands. They have a treaty with the United States, and the Constitution in Article 1, Section 8 limits the regulation of any commerce with Indian tribes to the United States Congress. This entirely excludes states from consideration in terms of negotiating directly with Indian tribes for cessions of land or any other matter. The federal government protects them. State law does not extend to the Cherokee Nation's territory. The Cherokee Nation and subsequent all Indian nations that are federally recognized have a unique status under federal law as domestic dependent nations. They are able to exercise sovereignty, legislative, judicial, executive functions on their lands and territories. Today, we have many reservations. There are 22 federally recognized tribes in the state of Arizona. Over almost a third of the state, quote unquote, is tribal trust land. This is a separate territory and separate political sovereignty from the state of Arizona. So it sets up that character even in the modern day. So the doctrine of discovery was a framework instrument in federal Indian law. It is of continuing validity, and yet we can't really accept it as the charter of justice because it is based on those political and legal hierarchies that Professor Branco talked about that basically negate the full self-determination of Indigenous peoples. So before I move on to the human rights framework, I want to return to one thing that Professor Branco said, which I thought was extraordinarily important about the character of the clause, Indians not taxed. This comes up a lot in contemporary affairs where political leaders want to know, well, now that American Indian and Alaska Native people are citizens of the United States, do they still have the right to self-determination? I mean, do we have to think about sovereignty in any different way than we would have at the time that those treaties were signed? And the answer to that is that the US Constitution set up a framework where Native people were not constitutional citizens and had no right to representation in Congress as citizens did, to be counted for purposes of representation, direct taxation, and that is the operative clause in Article 1, Section 2 of the US Constitution, which was ratified in 1789, talks about the fact that you're going to count whole persons, which is free persons, Black slaves at that time, although they're designated as quote unquote other persons, were 3/5 of a person, and it says exclude Indians not taxed altogether. They're not even counted for purposes of congressional apportionment and representation. Did the 14th Amendment change it? A lot of people think, well, yeah, they're natural born citizens. They were born on US land. And the answer is no, it didn't change it because the 14th Amendment, although it clarified that whole persons includes everybody, including African Americans, it still excluded Indians not taxed. So as of 1868, when that was ratified, the Indians still weren't constitutional citizens of the United States, still were not counted. What was their status? They were considered wards of the federal government, non-citizens. They were citizens of their indigenous nation with full rights of nationality in that indigenous nation, but without the freedoms and civil rights that other natural born citizens had in the United States. So that is why we have the legacy of boarding schools, forcible removal of indigenous children, bans on native religion, speaking native languages, the host of things that would be really associated with the core rights of autonomy in an individual. Civil rights and human rights were denied to indigenous peoples as wards of the federal government. And that did not change until 1924, when Congress passed the Federal Indian Citizenship Act that extended federal citizenship to all American Indian and Alaska Native peoples and their descendants further, but also has a clause that says this doesn't change anything in terms of the indigenous peoples retaining their treaty rights and their full rights to be members of their nations on their land. So that statute set up dual citizenship, indigenous and US citizenship. And it wasn't until the 1950s and 1960s that through a series of court cases, Native people secured equal rights as state citizens for voting and for, certain forms of education and health benefits. So it's been a pretty hard road to equality in terms of the rights of indigenous peoples. Okay, so what can human rights law offer us in terms of a corrective for the multiple forms of injustice that have resulted? And so here I want to say that the first harm of the doctrine of discovery in that colonial history is to negate the central importance of indigenous legal systems. They're invisible for the doctrine of discovery. They are now visible in international human rights law. Indigenous law is of vital importance. The domestic law, in our case in the United States, federal Indian law, is the discourse of the federal government negotiating sovereignty or self-governance rights with indigenous peoples. But really, international human rights law says the goal is to effectuate indigenous self-determination. And that is autonomous governance of their people under their law on their territory. So Article 1 of the UN Covenant on Civil and Political Rights distinguished between peoples who had a right of self-determination and ethnic minorities. And it wasn't until 2007 that international human rights law recognized that indigenous peoples are peoples with the same right to self-determination that all other peoples have under international law. There is not the remedy of secession from the United States. Indigenous peoples are said to be in their location in a way that doesn't dismantle the territorial boundaries of the nation state, but they have to, the nation state has to negotiate the conditions of equity for the right of self-determination to thrive. And this is the way that international human rights law works. It says the past is one that has to be repaired. All of those past wrongs and injustices have to be repaired. The present is the moment where indigenous peoples and nation states come together to negotiate a better framework. The future is one where the institutions of society are reformulated in a way that is respectful. And so the idea is a political partnership between nations, nation to nation, that is based on justice and not on these antiquated doctrine of discovery hierarchies. So that is the goal. And it recognizes collective rights of tribal nations as well as their individual rights as citizens of the United States and the states where they reside. Now, how does it work? That's the architecture, right? How does self-determination work? And it can work in a variety of ways. In the United States, it works in multiple ways. The sovereignty of federally recognized tribes, and there are now 474. As of 1970, there were about 30 less than there are today. So it takes a long time. There's still a couple hundred or more that are petitioning for federal recognition. So the status of federally recognized tribal government is limited. And this extends to all Indigenous peoples, so includes peoples that are not in that formal relationship. But in the United States, the sovereignty of self-determination, that is the gold standard, I think, of what Indigenous nations aspire to. But other ways to effectuate that are corporate models of governance. You see that in Alaska. There can also be intertribal courts of appeals, things of that nature, where they collaborate. There can be co-management agreements between other governments, state and federal and tribal governments, for resources like water or forest resources that transcend the boundary lines. And participatory governance, the right of individual citizens to vote in elections and to hold office, whether that's on state courts or transportation boards or education boards. And Professor Rinko is doing amazing work in that space in education. I really applaud your work there. But these are ways to grow beyond the parameters and the restraints of what we have now into a robust model of self-determination for Indigenous peoples. There are three themes that are stressed over and over: recognition of the people in their identity under their law, reparations for the harms, and we can see that now in the boarding school context, where Secretary Haaland is calling for this inquiry to figure out the nature of that harm and injustice beyond the kind of vague parts of that. What was the specific nature of that, and how do we correct that in the present day? And then reconciliation, which is bringing people together. And here, I think for Q&A, I would love to hear about the experience of Maine, but how do you bring people together, not in that oppositional context of, because this can lock people down. It is locking people down in Arizona, water rights. Who has the property right to this water? Those battles can go on for 50 or 100 years, but more in the sense of what do we need right now as people sharing a territory to honor the things that the territory needs and that we need to create the best future for the children. So that is really the aspiration. So I know that I'm getting to time, and I'm gonna wrap up with a couple of thoughts. So since we started with the doctrine of discovery, let's talk about reparations in a sense for the dispossession of land, which was a huge harm of the doctrine of discovery. The UN Declaration on the Rights of Indigenous Peoples has an article which is unique in international human rights law. It's Article 25 that says Indigenous peoples have the right to maintain and strengthen their distinctive spiritual relationship with their traditionally owned or otherwise occupied lands, territories, waters, coastal seas, and other resources, and to uphold their responsibilities to future generations in that regard. That is a powerful statement. That is Indigenous law and epistemology at the heart of it, because that relationship is spiritual, it's intergenerational. That doesn't mean it's religious, quote unquote. It's spiritual in the sense that the understanding in Indigenous law is that there are these obligations to the earth, to the water, to the species, and that there's an interaction and a balance that needs to happen in order for the conditions of sustainability or resilience. And I'm using those Western terms out of climate, law, to really ensure the survival into the future. So thinking for the future generations, that's embedded in that. A much different ethic, and Article 26 talks about that extending to nations need to acknowledge the rights to land, those former lands and the current lands, all are important to Indigenous peoples. There are a couple of examples that are very inspiring. The Canada's Supreme Court recently held in a case that a tribal member of a US tribe, a Colville tribal member, who was hunting in Vancouver without a permit, but in his ancestral territory, that he was entitled to exercise those Aboriginal rights because his people had been involuntarily pushed down into the United States from his ancestral territory, and that he had full rights to hunt, even though he was not a Canadian citizen, and even though he had not secured a permit to hunt there. That is a powerful statement of the trans-border part of Indigenous identity for many Indigenous peoples, and that is Article 36 of the UN Declaration says you must honor those territories, even if they extend across the borders of an international nation. The Lummi tribe in Washington is another one for those of you interested in climate change. The Lummi people were being heavily impacted. They have hunting and fishing rights throughout their territory in those Stevens treaties, even off reservation. But they were basically being in an onslaught of pollution by the oil refineries and the aluminum smelter and all of this. They asserted their traditional knowledge as science and participated in the formation of the most protective part of coastal permitting in the nation that I'm aware of, in collaboration with the local communities because of the impacts of climate and the impacts on marine species and fish. They then took that into Canada, where they're not recognized, to serve as stakeholders on the traditional part of their territory in Canada. So they're not recognized under Canadian law, but they were asserting a position of stakeholders based on their traditional identity. That's the way that Indigenous self-determination ought to work today, because the main problem with the doctrine of discovery was the hierarchy in terms of knowledge systems, that separation. And we see that in so much of Western law. Property's here and water is here and intangible property rights are here and mind is different than body. And let's not get confused about religion with secular. All of those divisions and hierarchies are destructive. We have the power to recreate these frameworks of law and governance in a way that truly achieves justice for the people. Thank you so much. It's an honor to be here today. Thank you.
Thank you so much, Professor Sosi. Really appreciate the presentation. And I think everything you just went through is a perfect representation of how you hooked me in this field. I want everyone just to know that this topic, this whole panel, the genesis of this was work that I did with Professor Sosi when I was at Arizona State University a couple of years ago, putting it mildly, a couple of years ago. It's been a few years in that now, a few years more than that, but we have some great questions from audience members. And Professor Ranco, if you're available, I'll ask you to come back up and I'll pose some questions to the group here. And if folks have any more questions in the audience, please continue to put them in. We are doing our best to sort of triage and put questions together. And so we'll get to all the questions that we can. One question, and this is it's not necessarily specific to the presentation material today, but I think it's a relevant one nonetheless. For those folks that maybe don't have a lot of knowledge or experience working in Indigenous communities. And this question is, why is the term Indian used rather than Native Americans? Or is there another term that's more appropriate to use when referring to Indigenous peoples? Professor Ranco, you care to take a stab at that one first?
Sure, Corey. Thank you so much. And as you know, these mostly seem like questions from non-lawyers, so that definitely helps me. I'll say, like, I mean, I think the term Indian is actually in those treaties, right? So I think as it is in federal Indian law, if you were to ask, I think most tribal citizens of nations, we would definitely prefer our nation to be used as the term of in that way. And I don't have a particular allegiance. I think Native American can sometimes be as misleading as Indian. But I think what we're stuck with many times is the fact that the language of these treaties and the language of in these laws of these legacies of referring to them as Indians. But I think Professor Sosi talked about, I think a more accurate terms are indigenous. That's in the contemporary federal framework. So I would probably, I think we'd use indigenous a lot in terms of our scholarship. I think in social shorthand, Corey, I think I say native a lot, but what I really mean is indigenous. Is that's a catchphrase for me in my mind that I think a lot of other indigenous people use in the North American context, say native, and I think that's a reference to being indigenous. I don't know if that answers your question.
It's helpful. Thanks, Professor. Professor Sosi, anything you'd like to add on to that?
I had a contingent of students this year who heard another professor say Indian the first week of class, and they were in my office and they said, this is racist. People should ban the use of Indian. I don't like it, da, da, da. And I told them, well, it's a term of art in federal Indian law. We have the Indian Child Welfare Act. We have all these statutes, so we can't exactly negate it. But I think what you're getting at is that sense of the fact that indigenous identity is being defined by some other group. So Columbus got lost and all of a sudden he thinks he's, I don't know, in the Indies or something. So it's Indian. So that's one of those fictions. But today it becomes meaningful because it's a term and it's distinct from, for example, the Inupiaq people or the Aleut people. They're not Indians. They want to be Indians. So we have Native Alaskan for them, and Native Hawaiians aren't in any of those categories, and yet they're indigenous. So Native American is used comprehensively to include all of those groups, but it has that hybrid identity like African American or something like Italian American, which people really rail against, which is why they leave off the American and they just say Native.
Thank you. It's interesting. I'll just add in here, sort of like colloquially speaking, even in my own community back home at Zibayik, I hear people use the phrase like Indian, like we're speaking our language, like we're speaking Indian though, or we're getting together for dances or ceremony, and what's going on? We're going down. We're going to be doing some of the Indian dances, and I know that sounds funny to folks, but every community, they have their own, ways of referring to themselves in those communities. But I would caution against using the term the Indians when referring sort of pejoratively to groups of people. But to the professor's point, this is federal Indian law. It's very much a term of art, and the United States Constitution itself uses the word Indians for better or for worse. So it's just one of those things that, I think if you were to ask, 10 different folks from across Indian country what they'd like to be called, after they say, call me by my, my nation, some might say Indian, some might say Native, some might say Indigenous person. I don't think there's a right answer. And so, it's a great question to ask, but I wouldn't get too hung up on that. Great question though. Thank you. Here's another question that I think is in this vein of concepts that tie to use of language. Okay. And this question I really like it, and I'll just read it verbatim. It seems that the lack of shared concepts for the same words, property, discovery, ownership, still plagues our attempts to resolve issues today. How can we address this? And so I think this kind of gets to like, how do we develop shared understandings of these concepts that have been applied disparately? Professor Sosi, would you like to take a stab at that one?
Thank you. I love that question. And you could teach an entire class on just that question, because you're absolutely right that in order to create a better future, you have to have a shared understanding, and the meaning that attached under these colonial frameworks was all one-sided. And that's a form of what Miranda Fricker, the philosopher, calls epistemic injustice, right? Because there wasn't a co-creation of meaning with Indigenous peoples. These terms were plopped on them, and then they said, no, you don't have titles, you don't really have property, and da 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 da. And we still do that today. Oh, it's driving me crazy in the world of water law right now, where we have these stupid notions of separation between surface and groundwater. It's insane. We need better concepts and terminology to describe how to keep the land and the water in integral form for the survival of everybody. So co-creation of meaning is where we're at. And Indigenous language is powerful, but a lot of people, of course, are still in the process of relearning traditional languages.
Yeah, I'd echo that too. It's almost like there's almost like a recent case, Corey, where the definition of island separate from water might have held sway. So I think, yeah, I think that co-creation and the forms of epistemic violence, having in these interpretive frameworks just from a single side, and really addressing that in significant ways, and in forms of, this stretches all the way from how we train people in the legal profession or at society at large, but also how we, I think, Corey was in a meeting with me yesterday where, it was Wabanaki nations trying to secure land return and access to conservation lands. Those concepts through the frameworks that are Indigenous oriented. And I mean, I think for us, as we think about what is our framework of a sovereign or as a political set of relationships and responsibilities to each other and to places, that is core values, Wabanaki forms of diplomacy and responsibility. So I think, I think it's on our side, as Indigenous scholars, to communicate our interpretations and our frames, but I think in society at large to take those up and recognize them. And I think that there are opportunities in legal frameworks to do that, but it requires a real recognition of the partiality and bias of the current systems and definitions. And I think accruing that, the fact that you could, say an island has meaning outside of water or anything like that, requires a sort of contortion and ignoring of certain other frames.
Thank you. Really good responses. I like thoughtful responses to a really thoughtful question. Our next question is a bit more historically oriented. So Professor Ranko, I'm gonna put this one towards you first, but a couple of folks have picked up on something really interesting. They've inquired about how the doctrine of discovery was employed by Great Britain in the years following England's break from the Roman Catholic Church. And in particular, folks are wondering if the English paid attention to the fact that the doctrine was derived from papal bulls. Were the English simply wanting to shed the church and the directives of the Pope, but to continue to sort of employ some of its legal principles? How did that history play out? Any idea?
Yeah, I mean, I wish I knew dates of things, but I'm not a historian, so I'll just punt on dates. But I think the framework gets employed and brought into English common law in sort of it becomes kind of the law of nations as well. It in a great and Professor Sussy talked about that. It becomes a framework. Ironically, it's a framework that the European sovereigns at different times recognize amongst one another. And in Robert Miller's work, he even talks about, sort of the idea of how far does the claim of a European sovereign go compared to another claim, at different times of a separate European sovereign over similar indigenous territories. And they start out with sort of, frameworks of like halfway between our two claims is where they end. And, at times that, so they incorporate a whole series of kind of rubrics around it, and I think his work is good in detailing some of that, and other people have written about it as well. But yeah, and I think some of the break from, in the creation of the Church of England, the break there, they incorporate so much of sort of church doctrine and law from the Catholic, there's a sort of recognition of a whole series of things that are official in that. So I think part of this becomes at some point it becomes a part of the law of nations, kind of set of frameworks, and it's recognized in their various treaties with one another.
Thank you. I'm going to move on to another question because we're starting to run a little bit short on time here. A couple of folks have commented on recent movements for folks from indigenous communities or elsewhere to present to the Catholic Church and to other Christian denominations the opportunity to renounce the doctrine of discovery. Do you see any of these efforts being successful? And if so, what impact might a denouncement of the doctrine of discovery have on indigenous peoples and the field of Indian law? Professor Tsosie?
That's a great question. So the mythology in the United States is that there's a separation of church and state. That's false, right? So as Professor Renko noted, it was paramount that those Christian European nations got the charter of the Pope, the religious kind of sanction, because of natural law. Natural law had a theory of justice embedded in this, and that was aligned with Christianity. By going to these religious denominations and asking them to renounce, you break in a sense, the spiritual part of that authority, which was very paramount in even articulating what a just war was. They determined what a just war was, but the impact was devastating on indigenous peoples, and look at the genocide that happened as a result of that. So I do think there's a powerful spiritual agency in renouncing that. The question is, what does that mean for nation states? Can nation states also renounce the doctrine of discovery? And I think that there's not a harm in doing that, in the sense that we're rebuilding principles of justice and acknowledging the legal fictions of the past that were so devastating to indigenous peoples. So that would just be my personal take on it.
Thank you, Professor Tsosie. Professor Renko, anything you want to add on that?
No, I would talk about something else, but I think I think what it gives is a framework, as a social and political one that is much like, again, our work from yesterday, Corey, but also something that Professor Tsosie references. The forms, what it gives way to is the forms of reparation, or at least the contemplation of a reparation framework, given that once it's now renounced, you have to sort of do that, like, well, now that it is no longer legal, what is our responsibility to the restoration project based upon illegal forms of takings? And I do think that that's, and that to me is about then return. It's about a broader set of recognition around rights for indigenous peoples. And I think that's what I think it's, to me, that's my understanding of what it gives way to, is a more vibrant and possible discussions of, we need not call them reparations, but fixing the illegal, the now illegal frameworks that have created injustice. Yeah.
Thank you. Well, so just to kind of continue on this theme, a few folks have asked, what can we do from our armchairs behind the computer? Is the giving back of land what would be helpful? Is it exploring further this idea of reparations? And I think what reparations are is something that I think a couple of folks have commented on. So Professor Tsosie, where do we go from here? What can we do to begin to correct these historical injustices?
So thank you for that. I am firmly committed to the vision of a better future. So I try not to get locked down into injustice as having a a sort of effect. There was a recent speaker at the law school who a student asked that similar question, and the speaker said, we want to forget about the past. Don't live in the past. You're an equal citizen. Go forward in the future. You're an American. Don't worry about the past. That isn't true. So you must account for the past harms in order to rectify them. And that is a fundamental principle of justice as healing. It is a process. I have to say, in my work with repatriation, ancestral human remains, funerary objects, sacred objects, objects of cultural patrimony, that is some of the most painful work of reparative justice that I have ever witnessed. But there's a profound healing, and even for the museum people, the agency people who have custody of things they shouldn't have custody, to see them emotionally get into that work and to realize that this is the right thing to do has been profound. So I think that that is the sort of object of every person to know what the past is. This should be taught in schools. I'm adamant. I know you have a law in Maine. I hope it's working. What we've been trying in Arizona for a long time. It has to be taught. People have to know this, and then they have to come together in that idea of how are we going to create a better future.
Yeah, hopefully I can have a minute. I think just extending that notion of return, I think, and I just see this in the questions, that the framework around lands returned or access is actually less about, I mean, I think title is important to property. I'm not dismissing it out of hand, but only to the extent that it is a reparative. It allows for Indigenous repair and healing work related to our places. So, I can get, there are all sorts of reasons why actual land returned to us as tribal nations is preferable to some other techniques. That said, the actual goal is our relationship and repair with our human and non-human relations as Wabanaki people. I think that's the healing work around quote unquote property, much like it is in terms of the healing work that Professor Sosi talked about with our ancestors. So I think that it's about reorienting a framework of healing that has been disturbed and disrupted through destruction.
Thank you, Professor Ranko. Well, we have a couple of minutes left, and I'd just like to say in closing for myself that I'm extraordinarily grateful to our panelists, Professor Sosi, Professor Ranko. You are just amazing scholars and individuals. I look up to you both, and I'm truly thankful to you for being here and for your time spent preparing for our presentation today. I'd like to again thank our sponsors. And for closing words, I'd like to turn things over to Will Sedlak and Professor Anthony Maffa from Maine Law. Thank you, Wally one.
Thank you, Corey, and thank you, Rebecca and Darren, for joining us. And I hope you can hear me. I'm joining you all from Sharm el Sheikh in Egypt as part of the UMaine delegation to the United Nations Framework Convention on Climate Change. It is the end of the day here. A day that I saw some Indigenous protesters march by me chanting decolonize, and I think this was a fitting end to that day that began tonight. A lot of what I've seen here in Egypt at the COP from Indigenous communities resonates in this talk today. So I thank you both for the comments that you made and your discussion, and everyone for your questions, which were I think really excellent questions, really got the discussion going. I want to say to those who are still watching, this is a program that this is the second annual, as you can tell from your screen, and I hope the second of very many. And so if that's something that you also believe in, I hope that you'll support this program through the Law School Foundation, our sponsors, and I want to thank them for doing that as well. So I want to thank you for attending on behalf of Maine Law, on behalf of our Indigenous community here in the state of Maine, Indigenous communities all around the world, and also on behalf of our legal community, because this is information and knowledge that has for far too long been neglected by our legal community. And I'm glad to see that we're promoting it through this lecture, and I hope we can do so in the future. So thank you for joining, and I hope to see you sometime soon back in the United States.
Thank you, everybody.